So first up is Linda.
We're going to hear at least 3 versions of what the state means by regulation. At last Tuesday's board meeting, Bill PODULKA shared with us that regulation does not include bans and prohibitions. He is of the opinion that it is in local government's power now to ban gas development. The second version that you'll hear concerning what that word regulate means might include bans and prohibitions. So there are groups, and certainly the Home Rule Bill is one of them, that would like to amend or change Environmental Conservation Law Article 23. And most of those types of changes to the current environmental law run along the lines of it's okay for local government to prohibit gas as long as all similar industry is prohibited. You can't target oil, gas, and solution mining only. They can't be singled out. So supporters of this version are doing things like creating categories, heavy industry, and attempting to define what that is and capture the gas development within that framework. The third version of this concept of regulate is the simplest version, and it's the version that my resolution hangs on, which is that regulate actually means local government cannot regulate it, they cannot prohibit it, they cannot ban it. That the state has preempted that power. You're going to hear various cases cited tonight based on the information received from groups and information that Rouse provided and other resources. We had hoped, or I had hoped, to find a case that specifically answered the question, what does regulate mean in Article 23? Unfortunately, that question has been danced around with a couple of case decisions, but hasn't been specifically answered yet. We wrote the Caroline Neutral Resolution because until that jurisdiction is defined, either by the state or future court decisions, and the appeals process is finished, it is not possible to write law to an unknown precedent. Doing so burdens Caroline with risk, very expensive legal suits. It is not possible to know how lengthy they will be, not possible to know how many there will be. As discussion takes place tonight, you're probably going to hear the words if and maybe and could and someday. The resolution that we've proposed is based on current law. It does nothing to restrict activity. It can be refreshed as law, and the courts make these decisions clearer. Thank you very much.
So next speaker.
I'm working this one.
Okay.
Because I need to face everybody. I don't know if I can quite do that. All right, I'm not sure I can even stay close enough to the mic. We'll see. I can't stand in one place when I talk, but all right. You guys ready? All right, so I'm a Caroline resident, and I'm also chair of ROUSE, which is the Residents Opposing Unsafe Shale Gas Extraction. There are obviously a lot of people in this room tonight, and not everybody will probably get a chance to speak, and not everyone may be comfortable coming up to the microphone to speak in front of such a large crowd. So I want to start with a short poll. And I want to restrict this to people who either are residents of Caroline or own land in Caroline. And this is not to denigrate the perspectives of people who don't live here, but since this is in part related to a petition that we've been bringing for residents of Caroline this is another little window on Caroline for the town board. So if you own land or are a resident in Caroline and you agree with me that we should consider banning high-volume hydraulic fracturing in Caroline and therefore vote down this resolution, please raise your hand. Okay, put those down. If you're a resident of Caroline or own land here and wish this resolution were passed tonight, please raise your hand. Okay, thank you.
Bill, I missed. What's the second poll?
The second one is your side, Milton. Now, I am opposed to this resolution because it's premature, because it ties the board's hands before all the facts are in. And part of the process tonight is bringing some of those facts in. It's also anti-democratic because it cuts off the voice of the people, and clearly the people want to speak with so many of you here. So I am asking the resolution sponsors to withdraw the resolution, and failing that, I'm asking the rest of the board to vote down against this resolution. You'll be hearing from much more impassioned and eloquent speakers than I am. It's just the way I am, I'm sorry.
I set you up perfectly.
Yeah. And there's no doubt that there are going to be a lot of statements both for and against gas drilling. But that's not really the issue on the table tonight. The issue is, the main issue tonight is whether it's clear that towns are so preempted by state law that all they can do is protect their roads and problems caused by surface runoff, as is specified in the resolution. Now, this view of state preemption that was summarized by Linda comes from Environmental Conservation Law 2303, Section 2, and it speaks about regulation. And as she summarized, my view is that prohibition of an activity, that is not allowing it to occur at all, is not the same thing as regulating an activity, which typically is considered setting conditions, such as how high, how far away, what kind of cement, what kind of casings need to be used. And there is indeed case law that shows, in regards to mineral mining, that prohibition is not considered regulation. So I think that won't be a good use of our time tonight if person comes up here and says, well, you can't regulate, you can't regulate, you can't regulate. I know we can't regulate. I'm arguing case law shows that prohibition is not regulation. What I want to hear from the other side is why they have, what case law shows that prohibition is regulation. And don't worry, I'll leave all that really heavy-duty legal stuff to a couple of lawyers, David Slottje, who's speaking in a little while. And I certainly heard comments from the board and elsewhere that, well, you can always find a lawyer to take your side. And what I want to make clear to everybody, it's not just one lawyer. Okay, there are lawyers, many lawyers, who've looked at this and come down on this side as well. And in particular, municipal lawyers in Ulysses and Ithaca and Dryden have looked at this and agree with the Slottje's analysis and agree so much that they are actually proposing regulations, ordinances that will ban drilling or high-impact industrial use. So given that, why on earth are there these home rule bills in front of the Assembly and Senate? And some say that just the fact there are these bills proves that municipal governments are currently preempted. And while that's a good soundbite, it's not accurate. If you read the bills, and if you read the bill jackets, they state, and I just about quote here, that their purpose is to clarify the role of municipalities because some local government officials are confused about whether they're preempted or not. So they're not setting new law, they are clarifying law, which means they are telling towns what powers they currently have, not granting them new powers. And that finally brings us to the resolution in front of us tonight. The town board does not need this resolution to tell it what it can or can't do or what it wants to do. In response to the claim made last week by some proponents that they're just trying to save us time from barking up the wrong tree, I respectfully say that, well, that's not your job. And I will also tell you that, yes, we are fighting at both the state level and the local level. And win or lose, whichever happens in the resolution, we will still be bringing a petition to this town board. What we're asking for is the town board listen to that with open ears as opposed to a predetermined decision. The crime of this resolution is that the effect, intended or not, is that it stifles the voice of the people of this town, as expressed directly in the petition effort ongoing and in all the people present here today. So I've talked to a number of you on the town board and elsewhere, and I hear comments like, well, there are some who want gas drilling happening yesterday and some who don't want it ever to happen. And as you saw, there are plenty of hands on each side, though I think it's clear that a lot of people here are concerned about the impacts of gas drilling. So the implication the town is evenly divided is false. Nothing could be further from the truth. We've been out in the community petitioning and asking people what they think and would they sign our petition. And what I can tell you is that many residents have a sense of despair and inevitability about gas drilling. And you should see the light of hope that comes into their faces when we tell them that we believe a ban is possible. For those who are willing to give us an answer, and almost everyone has, 80%, 4 to 5, support our petition. With such an overwhelming support, is it not your duty to explore every possible legal option? Don't Caroline residents deserve to have a town board that leaves no stone unturned before giving up on them? This resolution is premature because it closes and locks doors before the town board even knows what's behind them. It is anti-democratic because it doesn't just ignore the will of the people, it stomps on it. Please don't pass this resolution.
It's hard to stifle enthusiasm. I would just point out to you that the more you clap, the less you'll be able to talk and listen. So you may want to, people do this, just like so just something to think about. All right, so thank you. Now we're moving on to David.
David Slottje.
David is here.
Is Guy Krogh here?
Guy's not here yet, looks like.
I asked him.
Is Guy here yet, Guy Krogh? Maybe he'll come by the time you're done. Do you want this guy here?
Should we take a break till Guy gets here?
Yeah.
I'd like Guy to hear this attorney's arguments. Maybe we could hear from some people and then bring the lawyer.
There's a suggestion that the other attorney should be here, Guy.
He just came.
He just came. Good time.
He had to park a mile away, right?
Okay, parking is tight, so.
I don't care. I just couldn't get in.
Why'd you sit down?
Sure? Yeah. Because I can stand over there.
There's another chair
Take
over there
notes.
too.
Take notes where you want.
So are you timing this? So you have 10 minutes, up to 10 minutes. This is our timer.
Okay.
Guy just got here. I got here late and just walked in as Don was explaining how this was going to work. What I heard was that there would not be a debate. That's absolutely the case. Guy's forgotten more about this stuff than I've ever known. And not only am I not going to debate him, I'm not going to debate him in front of this many people. So I don't want to disabuse anybody of any other thought.
Can you please speak a little louder for the people way back here? Thanks.
How's this?
Could we put this up here? Good idea.
And people hear me now?
Some people want to sit in the aisles. There's more room over the other side.
Fire hazard.
All right, if I step away from the mic and you can't hear me, just yell out and I'll step back to it. My name is David Slottje. I'm an attorney with Community Environmental Defense Council. Community Environmental Defense Council is a pro bono public interest law firm. Pro bono means that we work for free. I'm speaking here tonight on behalf of Residents Against Unsafe Shale Gas Extraction, or ROUS. I'm sorry, does this sound all right? I can't tell. Okay. The members of ROUS and other Caroline residents have so far collected the petition signatures of over 900 townspeople who are concerned about the negative community impacts that typically accompany unconventional gas drilling techniques. These signature collecting efforts are continuing, and plans are being made to make formal presentation of the petition to this board in the future. I am here tonight to make respectful request that you not pass the resolution that has just been introduced or talked about. We believe that the resolution's underlying assumptions are seriously mistaken, and that as a result, the resolution itself is fatally flawed. Parenthetically, I would like to note that we do accept the acknowledgement contained in the resolution that the town, and by extension the town board, has a fiduciary responsibility in this matter. However, we believe that that fiduciary responsibility extends not just to the protection of local roads, but as well to the protection of all of the town's assets, including does anybody have a paper towel for Mr. Krogh? Napkin, anything?
I'll get something later.
Okay, we believe that the fiduciary responsibility extends not just to the protection of local roads, but as well to the protection of all of the town's assets, including the rural residential character that so many Caroline residents hold dear. A fiduciary duty, by the way, is the absolute highest duty recognized by the law, and means in essence that the person charged with such a duty must protect the interests of those to whom the duty is owed, over and above the fiduciary's own self-interest. I want to say that again. A fiduciary duty is the highest duty recognized by the law, and means that the person charged with such a duty must protect the interests of those to whom the duty is owed, over and above the fiduciary's own self-interest. All right, now on to the parts of the resolution that we think are mistaken. We have been told that the sponsors of the resolution believe that it is neutral, in the sense that it supposedly seeks to preserve a neutral interpretation of ECL 2303-032, the preemption statute that is referenced at the first paragraph of the resolution. We have been told that in the view of the resolution sponsors, the preemption statute's prohibition against regulation of the gas industry precludes, as a matter of law, any and all action other than road use agreements by a municipality to attempt to protect itself from the traffic, air pollution, and other deleterious effects that even pro-industry supporters acknowledge invariably accompany unconventional gas drilling. And we have been told that the sponsors of this resolution had developed this belief in the town's impotence, at least in part by relying upon the opinion of a Caroline resident who happens to be an attorney, and who has asserted that, quote, reasonable minds cannot possibly come to any conclusion other than his interpretation, close quote, with respect to the preemption statute. Sorry, I'm addicted to that stuff. So, since the sponsors believe that reasonable minds cannot differ with their interpretation of the preemption statute is their articulated justification for introduction of the resolution, as well as the basis for their assertion that passage of the resolution is neutral, I would like to take just a moment to examine this premise. It is true that ECL 2303-032, the preemption statute, by its terms precludes municipalities from regulating the oil, gas, and solution mining industries. But that is far from the end of a proper legal inquiry. We believe that by regulating, the preemption statute means regulating the operational processes of the industry. That is, things like how deep they can drill or mine, and imposition of insurance and bonding requirements. And that although New York municipalities may not regulate in that manner, they may in fact prohibit such industries outright, either through zoning in towns where zoning exists, or through the use of other police powers available to protect the health, safety, and general welfare of the residents. The drilling statute language regarding regulation is almost identical to the language regarding regulation that was previously used in the context of the mineral mining statute. And in that context, the Court of Appeals, which is the highest court in New York State, made it clear that the scope of preemptive regulation meant regulation relating to operational processes, and that municipalities absolutely could prohibit mining outright, whether in certain zoning districts or throughout an entire town. We believe the same mining statute analysis obtains with respect to the drilling statute, and many, many New York State lawyers agree. Please keep in mind that our interpretation of the preemption statute is not particularly bold or visionary or clever or out of the box. This is not a situation where we are attempting to create new law or attempting to overturn a law that we do not agree with. or even trying to distinguish a holding in some lower court case that goes against what we are suggesting. And no one disputes that the preemption statute prohibits local regulation of the gas industry. But it is simply not the case that reasonable minds cannot possibly disagree with the opinion of the sponsors of this resolution that preemption with respect to regulation makes municipalities impotent with respect to the tool of prohibition or any number of other tools potentially available to the town. To suggest otherwise is simply inaccurate. The fact is that even as we speak, there are towns and municipal lawyers all over the state evaluating the reach of the preemption statute, and they most assuredly would not agree that reasonable minds cannot possibly differ with respect to this matter. Other towns and municipal lawyers have already completed their own analysis, and based upon their actions in passing or drafting prohibitions or moratoria, they too most certainly would disagree with the position of the sponsors of this resolution that towns are powerless other than with respect to road use agreements. I mean absolutely no disrespect to the author or authors of this resolution with what I'm about to say. And I apologize in advance if my words appear to be unduly harsh, but this is far too important a topic for me to mince words. The logical foundation of this resolution is fatally flawed. The sponsors' underlying belief that their own interpretation of the preemption statute is beyond dispute is wrong, period. There is no other way to say it. In our own Tompkins County alone, numerous municipalities and their experienced lawyers are working to attempt to find ways at the local level to protect themselves from this coming storm. Characterizing this resolution as neutral does not make it so. The width of this resolution's not attempt to either encourage or limit gas drilling, close quote language, would be laughable were it not so frightening. But make no mistake, board members who choose to vote for this resolution will be taking many, many protective tools out of the town's hands. For example, a town can prohibit through truck traffic on certain residential roads and or on other roads that cannot support heavy trucks. A town can post weight limits on certain roads and prohibit through trucks that are heavier than the limit. A town may prohibit unregulated pipelines, that is, pipelines that are not otherwise regulated by the PSC or by FERC. A town may regulate or prohibit disposal of solid waste. And by the way, drilling, exploration, and production waste are considered solid waste for this purpose. A town may prohibit underground storage of natural gas, unless the storage is associated with a major FERC project. A town may enact and enforce a sanitary code, air pollution laws. I could go on and on. But before you vote, please understand that if this resolution is passed, the town of Caroline will not be allowed to pass any such laws, at least to the extent that they would seem to fall within this resolution's admonition against doing anything to limit gas drilling. I'll finish instead. Why in the world would a town board even consider hamstringing itself like this? Isn't it this board's duty to protect the town? Doesn't the resolution itself use the term fiduciary? I've touched upon a number of legal issues tonight, and without question there are many more to discuss. But keep in mind, tonight is not about whether the town should do something to prepare for the coming onslaught. That discussion is for another time. The question for tonight is whether the underlying assumption on the part of the sponsors of this resolution as to the irrefutability of their interpretation of the preemption statute is correct. I have tried to show that it is not, and that by passing this resolution, those voting in favor will be placing the town of Caroline in grave danger by unnecessarily tying the town board's hands and removing tools otherwise available to the town. I've lost one page. My clients are asking that consideration of this resolution be permanently withdrawn. If the sponsors are unwilling to withdraw consideration of the resolution permanently, then in the alternative, we are respectfully requesting that prior to taking any vote on this resolution, the town board engage and direct the attorney for the town, Mr. Guy Krogh, to evaluate the merits and opine as to the validity of the sponsor's underlying assumptions regarding whether reasonable lawyers can dispute the sponsor's interpretation of the preemption statute, and whether passage of this resolution will or will not unnecessarily leave the town in a weakened position by taking potentially valuable tools out of the hands of the town board. In evaluating our latter request, we would point out that there are at least 2 additional weeks before any permits can be issued vis-a-vis the S-guys, and that Mr. Krogh is by all accounts one of the best lawyers in the county, indeed in the entire state, as to municipal law issues. So there would seem to be no good faith reason not to grant our request in this regard. True, there would be the cost of Mr. Krogh's fee in undertaking this analysis. But if there was ever a time to get something right, it would seem to be this matter now. 2 last things. First, thank you very much for your time and attention tonight. And second, with your permission, I'd like to approach and give to each of the board members, the town clerk, and the attorney for the town a copy of my remarks. Is that acceptable? Thank you. And I'm asking that a copy be included in the official record of this meeting. Thank you for your attention.
I sort of feel like I got a custom introduction, but I'm Guy Krogh, and I'm the attorney for the town, and I work with a number of towns, 7 of them totally, in 3 different counties, and one thing I've learned is that each town seems to be taking a different view on A, is there a problem, B, what is the problem, and C, what authority do we have, and D, what level of risk are we willing to take to maybe push the level of authority that we have to test what are the limits of the law. Now, there's one thing that David said that I really do want to agree with, and that is there are some things that can be done. That's beyond dispute. The problem, of course, is different forms of preemption. The environmental conservation law reference that he made dealing with gas and solution mining is one issue of preemption. There's a lead case. It's debatable as to its meaning, but I think it's clear as to its effect that says that what this statute says and what the legislature's intention was, except as to tax assessment and protecting roadways, but out. Similar laws have existed like that in other states and even within New York State, and through judicial resolution and legislative action, the scope of municipal power was expanded. So, for example, even though at one time it was clear that a municipality could not regulate the location of an extractive mine, such as a gravel mine, because of judicial interpretation and legislative changes in New York State, now it is very clear, in fact the law is very specific, that you can zone extractive mining out of existence, and even worse, if you're a libertarian, or better if you're anti-mining, you can actually amortize them out of existence as a non-conforming use. So there is a lot of history to this that really needs to be examined, and I'm not here to say yay or nay to any one proposal. What I really want to outline is what some of the outstanding issues are that might need to be looked at before I would be comfortable going forward. And with that segue, I've done a fair amount of work in this field. I've been looking at this issue for over 4 years, which is, I think, a bit longer than most people were aware of what was really happening in this marketplace. And there are some things you can do where other statutes expressly grant you the power to do it. What you have is, for example, great example is aquifer protection, designation of critical environmental areas. There's different things you can do where you have express statutory authority to take action, and the answer is unclear when 2 public policies meet head to head. If the policy of New York State is stay out of solution and gas mining, but the policy of New York State is also you have direct authority under the Clean Water Act and the Environmental Conservation Law to regulate and protect your aquifers, especially sole source aquifers, what happens when those 2 competing public policies collide? What wins? There's not a lot of history in New York State with mining in general or solution and gas mining in particular, but illustrative cases from other states show that municipalities do have some power. New York is a limited home rule state. It's not a true home rule state. So even the home rule powers that the town has to affect changes, regulations, bans through zoning are still powers that are derived from the state. For example, the home rule powers in New York specifically say a town may not pass a law that contravenes a state law or regulates in an area where the state has expressly and exclusively indicated an intent to dominate in that field. What does that mean? Well, it means two things. Either there's express preemption, as can be argued for this environmental conservation law, or there's implied preemption. Implied preemption would be something on the order of, could a town enact a DWI law to regulate drinking and driving on their town roads? The answer would be no. New York has a very detailed regulatory scheme. You would be preempted from trying to create your own local law to regulate DWIs. Implied preemption and the preemption question in general are only touched on the state level by the environmental conservation law. There are other issues that will come into play depending upon the regulatory direction you want to go, including divisible load and heavy hauling permits, interstate commerce commission permits. There's some federal preemption stuff too in environmental laws which probably need to look. So what I want to do, instead of going on and prattling, I sort of just want to take a snapshot and let you know where I think some of the key issues remain to be examined, and why I think that working with other municipalities and working with David, these questions can ultimately be answered as best as possible. I don't think there's a 100% answer yes or a 100% answer no. What I think we're going to end up with, absent action by the New York State Legislature, is a gray area. So the other side of the equation is that we must evaluate the risk. What is the risk of getting it wrong? What is the risk of a lawsuit? What is the risk of spending the time and money to pass a law that is a toothless tiger that will not work? So we have to be on both sides of that equation. What are the remedies? What are the risks? Because I think a town board needs to exercise a form of judgment, and that is to balance the risks of doing nothing with the risks of doing something, with the risk of doing something and getting it wrong or getting it sued, even if you're right. There's a legislative balance, a legislative determination that needs to be made, and in my opinion right now, there's not really enough information on the table to make that determination. So I think a full preemption analysis is still needed, both implied and express preemption. I think that a historical analysis of the two different preemption statutes in mining, ECL 230303 subdivision 2 for solution and gas mining, and ECL 23-2703 subdivision 2, not that y'all are going to remember that, for extractive mining. Technically it's not extractive mining, it's in the mined lands reclamation law where that issue is covered. But these statutes use slightly different terms. They differentiate between what is an industry and what is an activity. And that has been extrapolated into the difference between regulating the industry and regulating the operation of the industry. That argument worked in extractive mining. It's uncertain whether it will work in solution mining, because not only is it a different body of law, it's a very different industry. In my opinion, the third point is nobody's really dealt with some of the key cases that are in here, and no offense to those that have researched, but there's a case called Envirogas. It actually has 3 or 4 generations of decision making behind it. And one of the things it said, and it was decided right after this solution mining preemption statute was written, and the court was dealing with a bonding question, but what it said was things like, when you've got something like this, you must have clear and concise authority in order to proceed, and the legislature left nothing up to the imagination. That language is problematic if you're going to be challenged, and you need to really map your way around it. There are a few other cases. There's now a backup position based on a case called Through Run, gravel, but Through Run is being extrapolated into something that it probably is not. It's a very limited case with a very limited holding. It is not a panacea for whatever weaknesses there may be in the argument. The theory that's underlying Through Run in a nutshell is prohibition is not regulation. Well, I'm not sure whose dictionary you would get that from, and there is a legal distinction there that needs to be examined, but it doesn't quite make sense, because it would seem to me, logically, that prohibition is exactly one of the most extreme forms of regulation. And if through run stands for that proposition, why are there not a whole battery of cases across a whole wide array of different industries saying that same thing? As far as I know, they're not. There may be, we just need to find out. As to takings, a zoning amendment that's properly adopted and reasonably related to the proper balancing of uses within a community is highly unlikely to create a takings case. But the last thing you want as a municipality is to be sitting in federal court with a due process claim, an equal protection claim, and a claim that you've taken due property without due process, all right? People don't want to lose property rights. The taking of property applies to real property and personal property. There's a theory called a vested rights theory, and that is if you spend all your time and money to go a permit, and then a town unfairly pulls the rug out from under you, let's not say town, let's say village, okay, because there's not one here. But a government pulls the rug out from under you, you may still have rights in that permit, even though it is not attached yet to the land. So there's some personal property issues that to look at in terms of the takings analysis, and they become important because oil and gas rights and how you acquire rights in the actual gas as opposed to the right to explore goes back to like a 600-year-old case on who owns a fox. I'm not kidding. It's the rule of capture. It's an old property case from the 1400s. It started the whole rule of capture theory. It comes about today, and it still applies in New York and in many places in the U.S. But what happened? The guy was fox hunting, shot a fox. The fox ran over a property line and died on a neighbor's land. The question was, who owned the fox? The place where the fox died or the place where the fox was mortally wounded? And they came up with this big elaborate theory called the rule of capture, but the real truth of the case was the Welsh judge decided on the Welsh guy instead of the Scottish neighbor. That's what really happened in the case. But the rule of capture was born from that. And because it's a personal property issue, there's an issue. It's important. On the other side of the coin, it's also a real property issue because the right to extract value from your land, whether it's the nutrients in the soil to grow wheat or corn, or the minerals in the soil, which you can also make money off, that's called a hereditament. And it's part of the bundle of rights you own in land. New York does not have a history of split titles. If you go to Texas, if you go to Oklahoma, you go to Louisiana, the Barnett Shale, the Lafayette Shale, there's two sets of titles running for each square foot of land. One is the mineral rights going underneath, and the other is the surface rights up on top. New York doesn't have that history. Cayuga County, North Cayuga County has some of that because the government kept all the mineral rights for the War of 1812 and is just not, federal government is just now giving those rights back to the farmers up there. We've gotten quite a few back. But that doesn't happen in New York, so there's also a real property issue hiding there. So takings really needs a really, really hard, close look because that's a very expensive. We need to look at exclusionary zoning. You know, the Supreme Court has a whole line of cases, as does the state of New York, that says zoning is the proper balancing of all interests in a community and in a region. Industrial, commercial, residential, recreational, educational, religious, etc. If you're going to use zoning to exclude one of those whole categories, such as industrial or such as farming, I'm not going to pick on industrial. Imagine the difficulty if you pass a zoning law that said, okay, no more farming, no more residential in our community. You'd have a problem. We probably need to look at it. I'm going to speed up now because I'm near the end, but we need to look at the contract clause and the commerce clause of the state and federal constitutions. There are constitutional issues that say, you, the government, shall not interfere with my free right to contract, and you, the state and local governments, shall not interfere with interstate commerce. Trade in natural gas, I have difficulty imagining something that has a bigger impact in national commerce. Home rule, I touched on earlier, it's very widely misunderstood. There's lots of general zoning issues in here, one of the most important of which, if you choose zoning or any land use-based regulation, is it's got to be supported by a proper study. You've got to have a plan. You've got to have a reason why you're doing it. You have to document and justify. That can all be done regardless of the position the town and its citizens ultimately wish to take. Finally, risk analysis is the last piece. There are some initiatives that I'm supporting, some I'm not, but the real truth is we still have work to do before we know what will work and what will not. So, in all, I believe the preemption issue is a very real issue, and my gut instinct is that many things are preempted. But I also know from experience that not everything is or will be preempted. So with that, all I'm going to say is that I think the town board, in terms of its fiduciary duty, does need to know what are the options, what are the risks, so that they can make a legislative determination by weighing them and doing what they think is best to preserve what it is they like and what it is you like about your community. Thanks.